Welcome to the NCDWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NCDWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 156 of the NCDWI Guy podcast. On today's episode, we have a very special guest, a guest that is near and dear to my heart, Professor Scott Broyles. I call him professor because he was my professor at the Charlotte School of Law in a number of classes. I feel like Professor Broyles taught like a third of the courses during the first couple of years at the law school. That's probably an exaggeration, but he taught criminal law, criminal procedure, constitutional law 1 and 2. He taught contracts 1 and 2. He taught lawyering process. He taught secured transactions, philosophy of law. So it was a full gambit of classes, and I got to take many of those with Professor Broyles. I also got to serve as a research assistant for Professor Broyles while I was at law school, and consider him a close friend in addition to being an amazing educator and somebody that I found to be very instrumental in my understanding of the law. Professor Broyles is a former United States assistant attorney, U.S. attorney. He served in the Western District of North Carolina. He spent 10 years at the U.S. Attorney's Office, specializing first in organized crime and drugs. He later moved into the white collar crime division, where he was an assistant appellate chief, Anti-Terrorism Coordinator, and international coordinator, leading anti-terrorism and international cases. During his tenure with the federal government, Professor Broyles received high honors as an outstanding litigator. He earned the OCD ETF Case of the Year Award in 2000 and the John Marshall Award for Outstanding Legal Achievement for Trial of Litigation in 2003 for successfully prosecuting the first case under the material support of a terrorist organization statute, which was United States versus Hammoud. Professor Broyles' first passion is in philosophical studies. He got his Ph.D. from the University of Dallas Institute of Philosophic Studies. He got his J.D. from Washington and Lee University. But Professor Broyles has always been, I think, a teacher educator first and foremost, before a courtroom lawyer, as amazing a prosecutor as I believe that he was, in terms of stories that I've heard. What is always first and foremost an educator. He most recently taught at Belmont Abbey in Belmont, North Carolina. And just retired at the end of last year from teaching. So very, very excited to have my good friend and law professor, Scott Broyles, on the podcast, and look forward to sharing his tips with you on practicing criminal law. I'm so excited about this, Professor Broyles. Again, but we've been talking here for a little bit, but you were my favorite professor at Charlotte Law. I feel like I took half of my classes from you between all of the different classes that you were called to teach, and I loved every one of them. Just enjoyed getting to know you in the classroom, and then more so as a friend outside of the classroom. So I am so very honored and grateful to have you on the podcast to talk a little shop.
Absolutely. Well, Jake, it's great to see you. And without us flattering each other, you were one of my favorite and best students of the thousands I've had. And we did have some fun, as well as learn quite a bit, and good football games and basketball and all that.
That's right.
Yeah. Those were good times.
It was good times. It was, I have nothing but really fond memories of Charlotte Law. So it's definitely, so valuable. I feel like the education, law school education that I got was very practical based. I've told that to a number of people in the community, locally here in Asheville. I just really valued the way that so many of the professors, including you, had that kind of prior experience in the courtroom or in the real lawyering world. And your experience at the U.S. Attorney's Office, I feel like that was constantly coming into the classroom, into con law, into criminal law, criminal procedure. So obviously you can't teach all of the amazing skills that you pick up through everyday life at the U.S. Attorney's Office for all those years. But what kind of led you down the road to law school in the first place, and then into becoming a federal prosecutor?
Well, Jake, I was at the University of Dallas getting my Ph.D. in political philosophy, and had a job offer in Iowa, and the salary was so draconian, in a draconian sense, I could barely survive on what they were. So I decided to go to law school, and so I went to Washington Lee Law School, and it was basically a financial decision. I didn't want to starve in Iowa, so the path led me to law school, and then out of law school, I took a job in Augusta, Georgia, as the old song says, which is no place to be, and except 1 week out of the year. And so I was there for about 6 years in private practice, and desperately wanted to get out of that situation in Augusta. It just wasn't the best place to be. And I had a friend who was Ken Bell, who's now a federal judge in Charlotte, very dear friend. And Ken and I grew up together. And Ken basically said, "Come on up to the U.S. Attorney's Office." And he was the number 2 man in the U.S. Attorney's Office. He was such a good prosecutor and so well respected that his recommendation paved the way for me to get a job at the U.S. Attorney's Office, and they offered, and I jumped.
Yeah, that's I kind of had a similar road to law school. I was in my senior year in college, and really didn't have plans figured out for after college. Graduated with a BA in philosophy. There wasn't any jobs for sitting on a rock anywhere, so it was kind of like, do we go maybe find the doctorate in this area, or what's the next step? So law school felt like a good spot, and obviously Charlotte Law was opening up at the same time, close to my hometown. So it just seemed like serendipity to dive right in. I didn't know anything about accreditation or anything about like what to, how to vet law school, but yeah, very, very happy with the decision on that front. So I, it is, but I do think that philosophical background does really help both in the kind of analysis of cases, dealing with people, obviously, in terms of the route that you took ultimately in terms of teaching. I mean, there's a lot of, to me, value in the kind of undergraduate liberal arts education that kind of went into law school. And so, it was, I think my favorite class in law school was the philosophy of law class with you over the summer following that first year. Was just a fun class, like, going through all of these different thinkers and looking at American jurisprudence. It was a blast of a class.
I agree with the way you put it, Jake. And first of all, I'm glad you got off your philosophic rock and started a legal career, because you were such a delight as a student and such a success now as an attorney. I, of course, my last 6 years got back onto the philosophic rock and taught at Belmont Abbey. Fortunately, I avoided starvation because I've been a lawyer for so long to deal with rock wages. But philosophy and political philosophy, you being a philosophy major and mine having had my doctorate in political philosophy, it's all about understanding the first principles which underlie the various arguments that are spun out of those first principles, right? and as it descends into more particular laws when it comes to jurisprudence. And so you can understand the motivating principles that underlie everything we see in the law and in society and culture today, much of which is obviously quite disturbing.
Yeah, it is. And I think it's so powerful to have that philosophical background when it comes to teaching mixed with practical experience is really invaluable, because then you kind of are able to take these practical points that really do help one succeed in the courtroom, but kind of looking at it in a bigger picture context, kind of asking the why questions of what is the reason to be doing some of these things, how can kind of beginning with the end in mind, so to speak, when looking at a case. So in terms of your time at the U.S. Attorney's Office, what would you say, you had the chance to sit across the way from a number of pretty incredible criminal defense attorneys. And so in terms of like common characteristics of either prosecutors, actually, honestly, or criminal defense lawyers, what were some of the common characteristics of attorneys in the criminal courtroom?
Okay, Jake, 10 seconds before we get to that, to your earlier point about philosophic first principles. Let's take an example. Look what happened with the situation at Stanford when the appellate judge was subjected to the vilest sorts of curses and attacks on his family. And,
yes.
Really, the attempt, it was clearly an attempt by those students, law students at one of the top law schools in the country, to silence him and embarrass him and utter unrepeatable vulgarities. And it shows the breakdown of a legal system which begins in law school. I mean, if that kind of abomination can take place at an elite law school, the question then would be, why did those students do what they did? And you could trace it back then philosophically to critical legal theory. There are other influences as well. But ultimately, there's some serious Marxist principles that underlie critical legal theory with identity politics and the things that we call woke for shorthand, that are the motivating factors, the first principles that we talked about, that lead to this kind of travesty that we saw. And if the law schools are going to behave in that way, then the entire judicial system obviously will follow. We see the weaponization of the law in all aspects of society today. So that just to finish our thoughts on that. The qualities of, let's start with the best criminal defense attorney. So I was at the U.S. Attorney's Office for 10 years, and I had some great mentors in terms of how to be a federal prosecutor. So I'll quickly start with that, if that's okay. How to
Please.
be a good, yeah, what I learned about that, because I was not a great prosecutor. I think I was a decent prosecutor. I think I was a much better teacher, quite frankly. And that's where my heart always has been. But I was a decent prosecutor. And as I mentioned earlier, my close friend Ken Bell is the federal judge now, along with Judge Conrad. He was an outstanding prosecutor. And he always said the things that are quite obvious. For preparation is absolutely key. You hear that all the time. It sounds trite, but it isn't. Absolute thorough preparation, knowledge of the law. And he would always instruct us who basically, he was our mentor. He said, anticipate what the defense attorney is going to do. What is his, particularly the best ones, because there are a lot of lazy attorneys on all sides of the courtroom. But anticipate what the criminal defense attorney, the good criminal defense attorney is going to do, because they're going to attack your weak points and shore up your arguments and your witnesses and your evidence of whatever sort. And always, so those 2 points again, always maintain your credibility with the court. And that means, and it's tempting sometimes, the pollen is out up here in the mountains of North Carolina. So
I hope that's a Diet Coke that you're drinking.
As far as you know. It is. So to maintain your credibility in the court, you have to avoid trying to shade your arguments in a way that you might think would appeal to certain jurors. And always just let the facts fall where they may. We always felt we had strong suits. We didn't bring them otherwise. And so honesty and credibility and those ideas of moral integrity, those things always come out. And and I think the judges and the juries almost always recognize those factors. So hard work, moral integrity is critically important. Anticipate your opponent's strategy and be prepared to meet it. And of course, know the laws of evidence, et cetera, and the elements of your indictment. Defense attorneys, the best I went against, I'll give you one example. So a defense attorney named Deke Falls. I don't know if he's still there.
You mentioned him many times in class.
Did I?
Oh,
yeah. He was a thorn in my side. Only because he was bright and well prepared. And he never exaggerated in a way that to contrast Deke with another attorney whose name I will not mention, who was very bright, and he was a defense attorney in our 5-week Hezbollah trial. Ken and I did against Hezbollah terrorists group in Charlotte. He would attack everything, this attorney, and even when this is advice for don't do this with a defense attorney. If you see, for instance, some possible evidentiary questionable point, and Ken Bell used to always tell me this: don't object unless you think it helps your case. Don't object because you can object or have some plausible legal theory for objecting, but object when and where it helps your case. O.J. Simpson trial. I know you were too young, but defense attorneys objected every question. And even though he got off, but it wasn't because of the defense attorneys, it was other reasons, jury nullification. But they objected to everything and infuriated the jury. And we could see, Ken and I could see during the Hezbollah trial that this other attorney's constant objections were not strategic. He was smart and he had a legal basis for him. And we could see the jury getting very, very irritated with it. So just as the prosecutor, the best of defense attorneys always maintain their integrity and their credibility, obviously well prepared. They have a sense for the trial, a sense for these are human beings in the jury wanting to hear the truth of the matter and not wanting to see legal gymnastics being played out in the courtroom. Right? You have to have a sense of human nature, a sense of the strengths and weaknesses, and formulate your questions and your objectives accordingly.
Yeah, it's interesting because I do think that where you started all that in terms of the practical application of these philosophical first principles through that Stanford example, and then also kind of how this plays out in the courtroom. I really think it's bad lawyering if you're just screaming at everything. If you're objecting to just everything that comes in with no thought as to why am I trying to sometimes I feel like you object to pieces of evidence that are helpful. It's like, just for the sake of objecting, and the maintaining this deferential attitude of humility, both to the judge as well as to the jury, to me is a very powerful defense tool. It is a really when there is a humble lawyer sitting at the defense table, and it doesn't mean you can't argue like mad. I mean, you can still argue like hell for your client, but you do it in a way that is respectful. And I do think I have had such tremendous examples in the Buncombe County Bar of attorneys who really are very graceful and deferential with their arguments, but really know the law. And so I think that combination of being prepared but then also, first of all, knowing when to shut up when it's not when it's not serving your client, but also that kind of lack of deferential attitude that I think is getting taught at law schools. I mean, I do think that there is a kind of a kind of an attack on people in positions of authority. And while that might be well placed in certain situations, the appropriate attack to that is to kind of have a thought out attack. And I think that also plays true in the courtroom for your client. If you're going to put up a good defense, it's got to be one, again, where you begin with the end in mind and kind of think through strategically, what am I going to object to as it comes into play? How am I going to speak to the jury in a jury trial in particular, but also to the judge? The jury's watching this entire interaction, and if they get the sense that you're being rude to your opposing counsel, rude to the officer, rude to the judge, it can honestly not really matter what you're saying. It could, the words coming out of your mouth can be, completely true and accurate, and that can be lost on the jury because of that kind of lack of deferential attitude. Again, no need to just bend over backwards, but at the same time, I think that there is a little bit of a lack of decorum sometimes that is kind of coming up now through law schools.
You and I are going to make the mistake of almost agreeing on everything we say to one another. That's okay, I suppose. It's such a disagreeable world, because I think you're spot on. I noticed that, again, none of this is flattering. When you were a student, you were a very humble student. You would express your opinions forcefully, but I never thought you were in any way playing a game or saying anything that wasn't your heartfelt opinion. It was always a thoughtful response, but so I sensed that.
Sometimes wrong, but it was thought.
Yeah, I remember far more often right.
But I meant it.
Yes, you meant your error. But then I remember, when we get out and play football and sports, because we were a tight group back then, that I saw your competitiveness come through, and oh my gosh, get out of Minnick's way. But to a counterpoint to the kind of thing we're talking about that makes successful, humble, thoughtful attorney, there was another law student, obviously, I don't recall his name, and he came after you at Charlotte. And I remember him in, I think it was criminal procedure class, and he had been under the tutelage of a criminal defense attorney in Charlotte. And he stood up in class and made the argument that if it doesn't get into evidence, right, because it's ruled inadmissible for whatever reason, it doesn't exist. Let's call him John. And I said, no, John, there's a reality behind the legal rules we're talking about. So the legal rules don't create the reality. The legal rules are meant to try to bring out the underlying reality. And so it does exist, even if the bloody knife that killed the child is not allowed for some reason, right? The Fourth Amendment violation or what have you. And so I think lawyers tend to some, the less successful ones, say there is this, it's kind of positivism, right? There's this body of legal rules that has its own reality, but it's not connected to an underlying reality, what we used to call the laws of nature and nature of God and the Declaration of Independence. That's the way lawyers used to think, right? Blackstone. The legal rules are built on the laws of nature and God. But now positivists, young lawyers, tend to say, no, there's entirely separate, simply creation of human beings, a product of human will without any attachment to an underlying natural order. And I think they lose the humanness of what it means to be a successful lawyer, the way you described it so well, humility being a part of that. People are human beings, despite all the false ideology being spread around the country and the world these days. Human nature is human nature, right? It's not I can choose to be a man or a woman, or choose to be 10 feet tall, or choose to be another race, or all the silliness that we're exposed to in identity politics and woke ideology around the world today. I think that the woke people, look at the Stanford students, they they are probably as moved by many things, but identity politics as much as anything. So they didn't care what the judge had to say, right? They had a predetermined answer to everything, and it's based in race or sex, class, economic class, and victims and oppressors, and they don't care, right, about getting to the truth and listening, right? They have a predetermined ideological blueprint that they're going to impose on things. And they're going to go out in the legal world and do great damage.
Yeah, I think, you know, the other piece of that is that it's actually not true that if it doesn't come into evidence, it doesn't exist, because there is so many times where the thing that is kept out of evidence because of an objection becomes more real in the jury's mind than if it had come in the first place. You know, there's this kind of just natural curiosity, natural like question of like, why was this objected to, and why aren't we getting shown this thing? And so now the imagination can run wild. And, you know, we practice mostly DWI cases. I can kind of think of a recent example here. We recently saw a case where there was a 0.05 blood result. And so the state objected to that piece of evidence coming in because there was no chemical analyst there. They hadn't subpoenaed the chemical analyst. You know, we hadn't subpoenaed the chemical analyst. So it's one of those things where there's this objection to, you know, the blood result coming in, which is the best evidence of impairment. I mean, in a lot of ways, like that's a, you know, tough thing for, you know, for when it's good for the defense, it's hard to convict. When it's bad for the defense, it's hard to acquit. I mean, you know, it's definitely a pretty bright line in the sand. And so it's kind of one of those questions, even without that coming into evidence for a judge. It's, well, why are you as the state not wanting this piece of evidence to come in? And so it's hard to mentally get over that hurdle of that coming out. And so I think that kind of tying back into, you know, just objecting to everything, even if you're successful on some of those objections, had the evidence come in, probably most of it doesn't do very much damage. I mean, it's, you know, it's basically, you know, not even relevant to the outcome of the case or to any of the elements of the charge. But by keeping it out with an objection, now the jury's thinking, well, why aren't we hearing about that? Like, why is this attorney trying to hide everything? You know, so again, I mean, there can be very powerful and necessary objections to evidence, but that's why thinking big picture is important when it comes to those things.
That's right. And that's a great example.
Hey, podcast listeners, I want to briefly interrupt today's episode to invite you to join me at the inaugural Freedom Fighter Summit in Asheville this October. This in-person only event is designed for growth-minded lawyers determined to take their criminal defense practice to the next level. Due to the size of the summit's venue, there are a limited number of seats available. Don't miss out on the incredible lineup of speakers and spectacular networking opportunity that this summit provides. For more details, visit www.miniclaw.com/summit. Enter the promo code NCDWI-GUY, all lowercase, all one word, at checkout for $150 off your summit ticket. Look forward to seeing you there. Now back to the show.
5-week Hezbollah terrorism trial that we had in Charlotte. We had a piece of evidence that showed one of our defendants, our main defendant, Mohammed Hammoud, was sending money back to the Hezbollah group in Lebanon and Beirut. And the former spiritual head of Hezbollah, a man named Fadlallah, and so it was a receipt, you know, of payment from Fadlallah, if I recall correctly, from Fadlallah to Hammoud, showing kind of a receipt for kind of a thank you for sending all this money to Hezbollah. And Deacon and the other attorney fought like the Dickens to keep that evidence out. We fought like the Dickens to get it in, and we won. But the jury was quite. Their imagination and their interest was piqued incredibly over this question that was of such critical importance. In that case, there was every reason in the world for the defense to try to keep that receipt from That's supposed to lie.
Yeah.
To our client out, they lost on that.
Yeah.
Yeah.
Yeah, no, but I mean the attention is peaked. As soon as there is an objection, I feel like whatever sleepiness there is to like the meandering way that a lot of testimony comes out on the witness stand, as soon as there's that like, objection, all of a sudden you wake up, as a juror, you think, well, okay, something important is happening. I don't remember what he said over the last 5 minutes, but apparently this last thing that was asked is of importance. So you really are like calling attention to things now. But I guess there's one strategy that if you literally object to everything, then that just puts the jury back to sleep again. But at the end of the day, I think normally your objections are calling attention to pieces of evidence, whether the evidence is kept out or comes in.
Only object, absolutely. And if you object to everything, as you say, it puts the jury to sleep. Well, this is just a lawyer being a lawyer, not helping the jury understand the facts and the underlying reality of the case. And that is exactly how it plays out. I guess the way perhaps you would agree that the way we could phrase it is only object not when you have a legal basis. Object when you have both a legal basis and it helps your case. And only then.
Yeah, I love that. I guess as you kind of brought a lot of these like practical tips that you had picked up through your years of experience into the courtroom, when it comes to criminal law and criminal procedure, what tips would you say that you were kind of emphasizing most in terms of like beyond just the law that we were studying in the classroom? What kind of hey, this is something that works? What were some of those kind of primary tips?
Well, some of the things we're talking about, we've just been talking about for the last few minutes, go to that question. And just having been in the courtroom for as long as I was, and now you're in a similar situation, have a sense of how certain laws and criminal procedure, certain things occur and are very important, where others are not, and they just you play out in class a real world scenario. I actually was able to do that more and more, and even at Belmont Abbey, I taught constitutional law there, and bring in, for instance, a Terry stop, real life example, or what there was between reasonable basis and probable cause, and things of that nature. So you had mentioned earlier that Charlotte law had its flaws, but the faculty was not one of its flaws. The flaws were higher up in the administration. And the faculty was called it practice ready, and they hired professors who had considerable real world experience. And I think that you and many of the other best students were always very interested in that fact, and you had mentioned it earlier. So just knowing what actually occurs in the day-to-day life of a trial and the human beings behind it, and then applying that to study of law. So the law becomes less a stale recitation of just legal ideas unattached to the underlying reality. We could take 1,000 examples of that. So many Fourth Amendment examples. I just mentioned a few. How that plays out. So that's why teaching. And I heard at an early conference when I began teaching that one of the experienced professors said that teaching law is 20% knowing the law and 80% how to present in the classroom effectively what you know about the law. Probably a bit of an exaggeration, but I would say it's at least 50%. How do you reach into the mind and heart of a young person and grab their attention in a way that is pedagogically sound, that advances your teaching, but engages their heart and mind?
Yeah, no, that's a beautiful way of thinking about that relationship between, again, what works in the real world and kind of that study of the law that does have to occur in law school as prep work or groundwork for that. In terms of the kind of trials that you had while you were at the U.S. Attorney's Office, and kind of getting prepared for taking those cases to trial, what were some of the fundamental focal points? So I guess, in terms of a case that came across your desk, what, if anything, like when you first looked at a file, were you identifying as being important? Should this case go to trial? And then as a kind of timeline went along and it got closer and closer to a trial stage, what prep work was kind of big picture prep work was critical for success on your end?
Okay, so the 10 years I was at the U.S. Attorney's Office, the first 8 years I was on what's called AUSA, Organized Crime and Drug Enforcement Task Force, which is basically large drug organizations generally that span many states, often from California, originated throughout upper Mexico. Of course, we should keep our borders porous and open so more of that can come in. I'm sorry, I lapsed into sarcasm occasionally. So those became fairly rote because you knew the illegal drugs. You knew basically somebody had flipped. Right? What you call flipping is someone who's been involved in the organization, and you give them a break on their sentence or your recommendation to the judge on their sentence, and they begin to work state's evidence or federal government in our case. So you'd line all that up. The elements of the case, as you mentioned earlier, you have to have the evidence match the elements, right? And if you see that the evidence is weaker on one of the elements, say an agreement in a conspiracy, a drug conspiracy, you have to have an agreement. Right? You have to make sure that agreement has a solid evidentiary base. That means witnesses, right? And so the preparation, now, the last 2 years, just to sidestep for a moment, when I became the head of the counterterrorism unit, which was extremely stressful. But and that was a whole new ballgame because the charges were so complex and you had to spend hours and hours and hours of preparation matching the evidence to the elements. For instance, material supportive terrorist organization, which is the main charge against the Hezbollah in the Hammoud case. Those were incredibly complex. 72 counts in the indictment. Ken had done most of it in Bell, now Judge Bell. And so that was incredibly complex, and we spent years preparing for those cases. But those are different cases. But the drug cases and basically conspiracy. Here's an area where I failed, and maybe be helpful for some potential prosecutors and defense attorneys. Is early on in my career there, I assumed that the agents, so the agents would bring the case, right? ATF, DEA, FBI. And I deferred to the agents. And there was a reason for that. They'd been on the job quite a long time, and they thought they knew better and often did. And early on, that was true. But I assumed that what they said about the witnesses was true. Now, I'd interview the witnesses prior to putting them in the stand. Here was a case dealing with an ATF agent. And so we had witnesses, and there's a lot of drugs in the Waitsboro area, a lot of cocaine from large drug conspiracies. And we had many, many witnesses who had flipped and were working for the federal government. And when the agent said, put this witness on, I deferred to him. Even if I had misgivings. There was one witness in particular, I can't recall his name, I wouldn't say it anyway, but so the agent said, put him on. Let's get all these folks on the stand. I didn't trust this witness, but I deferred to the agent. And that witness was actually cross-examined by the attorney I mentioned in the Hezbollah case that made too many objections. He's going on that himself. And this attorney tore that witness apart. And the defense attorney was very smart. And we lost the case. And the U.S. Attorney's Office doesn't lose many cases. We won about 98% of our cases. And finally, the witness was so befuddled because he was not an honest person. And the defense attorney said, "So you don't know what you're saying up there, do you? You don't know what you're saying. You know what right from wrong or false from." He goes, "Yeah, man, I guess you're right." Case was done. Case was done. So your witnesses, and I don't think attorneys, I didn't early on, pay enough attention to a thorough examination of your witnesses and having forecast and preparing for your questions, how that witness will actually perform on the stand. I didn't, lost the case, never did that again.
Yeah, I really think that witness prep, especially for the prosecution, is so important since you're the one responsible for proving the case. I mean, knowing how that evidence is going to come out. And it's so hard as a district court prosecutor, as you're, handling 100+ tickets and misdemeanor cases a day, to kind of filter through all that and be able to actually, have a meaningful conversation with your officer, the witnesses that are coming up for your afternoon assault charge, whatever it might be. I mean, it is a lot of work trying to kind of get those things to happen, but the more prep work you can do on that front. And I think also sometimes forecasting to the witness, if you haven't talked with that witness about here's what we're trying to do. Here's what we have to prove are these three things. That's it. These are the three things, because otherwise the witness is just trying to get up there with really no context of, why is my testimony important? Or I just want to tell my story. And I think a little bit sometimes, I mean, this is again, case by case dependent, but I think sometimes the prosecution could be a little bit more direct with their questioning of a witness to have it be more impactful for the judge or the jury. I think that there's this, because of this like fear of asking leading questions, or this fear of like being perceived as biased on the case, or trying to again, like lead the witness down this particular road. A lot of times I see prosecutors asking extremely open-ended questions. Tell us what happened next. Tell us what happened next. Versus if you got to prove three things, ask the questions that will get you to, and then let the defense, go meandering around through all of the rest of the story, or the witness wondering why didn't these other things kind of get brought up. But there's a lot of, I would say, unnecessary story building getting done by the prosecution a lot of times. And the other thing that I think is helpful in terms of the story that you just shared is, I think that there's a lot of young prosecutors, young in particular, just because there is so much deference to officers as you're coming in the first couple of years. To me, the best way to especially at the district court level where the stakes are pretty low, the best way to kind of help train officers is to point out where something was done wrong. And if that means that the case has to be dismissed, explaining that to the officer. Hey, this piece of evidence wasn't collected. We can't win without that. Here's what you should do next time. I'm going to have to take a dismissal. And I think so often, because of this relationship that prosecutors have with officers, which is close and has to be, very carefully kept to make sure that, there's a very good trust basis, between the prosecutor and the officer. There's this kind of unwillingness sometimes to be the bad guy, so to speak, or to be the person that kind of points out this mistake. Whereas I think 9 times out of 10, if you say, we can't prosecute this case, here's the reason why, here's what you should do next time, that will never happen again. If you kind of go through and, maybe even win the case, maybe have the conviction go through, the officer has not learned that lesson, and likely will either be more sloppy in the future, or just not kind of receiving the message. So I think, at the very minimum, whether there's some sort of dismissal or other kind of negative disposition, so to speak, from the prosecution's end that happens or not, I think pointing those things out to the officer is like one of the ways that the prosecution becomes a trainer for officers, which is a huge part of your obligations. And I think a lot of young prosecutors are very nervous about that, just because they want to be deferential to officers that have been there for 15, 20 years.
That's so well stated, Jake. Putting your finger on, I think, the problem that I identified a bit earlier is that relationship between, at the state level, between the officers generally. For me, it was the relationship I had with the federal agents and the officers, because we had a drug task force, which brought in local officers as well. And I was naturally deferential, liked them. In many cases, was friends with them, particularly the agents, and some of the, I just liked these cops. They were good guys, despite the silliness being trotted out against police generally today, stealing of police, unfortunately. They're generally pretty good folks.
For sure.
Rotten eggs in every element of society. But you have to almost, I learned the hard way after this case, is I would get to the point where, particularly with the officers I didn't know as well, and the new agents, I would subject them as a prosecutor to a harsh cross-examination in my prep, which I didn't do early on. And I took the frame of mind that they might well be lying, or at the very best were extremely sloppy, and I would then attack them in the prep. It wasn't always an enjoyable experience, but it paid off wonderfully well by removing myself from what you described so well as that relationship and that natural deference and that friendship that goes on there, and saying, no. This is what you're going to be hit with by the very best.
So much better to get that in a private office than in front of a jury and a judge. I mean, as much as it's painful or awkward, it's a lot worse when you're just left out to dry in the courtroom.
That's right. The state, unfortunately for the state prosecutors, you put your finger on it a moment ago, they have such a caseload that they simply don't have the time that we did at the U.S. Attorney's Office to do the kind of prep work that's often necessary, and the kind of witness prep that we've been discussing. And that's the way it goes. But that's their burden. They're trying to put people in prison. I was trying to put people in prison. You darn well better get it right. And so young and, all criminal defense attorneys are aware of this and have to take advantage of it. If you're not prepped, I'm going to hit you. I'm going to hit you hard in a fair and legal way. That's the reality of the state system, unfortunately. But the other thing is to conclude that we touched upon, it is difficult as a prosecutor. I know you've not been on that side of the aisle, but to particularly when you have a witness on the stand, you're absolutely right. You want to get to the heart of the matter and not dilly-dally, use your term. But doing that without leading the witness is tricky. And prosecutors have to make that balance, because it is kind of the who, when, what, where, and why. It's supposed to be the prosecutor's approach, rather than, did you see him have the bloody knife on the night in question? Right? Although that's a fair question, right? The leading question would, you saw him have the bloody knife on the night in question, right? Didn't you, Mr. Jones? That's a leading question, but you can get away with, did you see him that night? Did he have a bloody knife? And was it near the scene? And did you see him leave afterwards? Those are fair questions, right? But that gets close. It's hard. It's a tough line.
There's a fine balance there. I think one of the things that's so difficult for young prosecutors, I know you may have mentioned this at one point. I could be wrong about this, but there's so many kind of check boxes that you're responsible for and that you need to bring up. And if you are going through a case and it feels like, man, my officer has established impairment, and driving, we're all set, but you forgot to ask if it was in the correct county? Was this charged in the right jurisdiction? And so now it's dismissed on this. You kind of can get into this mindset of like, okay, I'm just going to operate off of this like standardized list of questions, and I'm not going to deviate from that, even if it's, somewhat boring or however you want to frame it. Like that, I want to make sure that I am not responsible for missing anything. And I think there is something to that in terms of preparation. But I do think that the more experienced prosecutors kind of take that standardized list of questions and then really focus them into the specific case. And I think the best defense lawyers do the same thing. I think on most types of charges, the big picture issues are similar. And so you can get into this mindset of here's how I'm going to attack the, horizontal gaze nystagmus. Here's how I'm going to attack the walk and turn and the one leg stand. Here's how I'm going to attack the, the breath test or the blood test from coming in. And, instead of kind of focusing on that specific case in front of you, it can kind of become, well, I'm just going to, again, kind of like we were saying before with objections, go after everything. I'm going to go after every mistake that the officer made. I'm going to kind of make a big issue about every single thing. And again, sometimes that may be the right choice, but I think being very analytical in terms of where you're going ultimately with your case, what type of suppression motion, or are you arguing, that the state or the government didn't meet its burden? That all plays into kind of how to drive those questions. So the more you kind of, I think, get used to doing these type of trials in the courtroom, the easier it gets to kind of finesse the questions.
Right. That experience factor cannot be overstated. And I like the way you laid out your approach as a criminal defense attorney. I know that if I ever have an extra beer at a pub in Asheville and get stopped, I'm going to call you. Of course happened. But and another high in terms of this having a feel for the case and knowing your witness, having your witness prep. The recent Murdaugh case in South Carolina, I believe it was Alex Murdaugh.
Yes. I didn't follow it much, so I don't have a good sense of all the details, but I mean, I know obviously what you're talking about. So
wasn't it interesting that the defense attorneys agreed to allow Murdaugh to take the stand?
Yep.
As a defense attorney, and I don't know what you would think. Murdaugh was infatuated with what he thought was his own intelligence.
Yep.
And being an experienced lawyer, that he could fool the jury, right? So that must have been some fascinating conversations between Murdaugh and his counsel as to whether or not he'd take the stand. Now he did, and ultimately it hurt him, obviously, because they could see he was lying, even through his intelligence and his legal experience. Those are tough decisions, aren't they? I don't know if you've ever wrestled with a situation on your side about, do I put that witness on or not? I mean, those are the kinds of questions. If you don't have a feel for the underlying human factors, the human nature at play, and you just approach it from a purely formal legalistic approach, you're not going to do well. You're not going to make the right decision.
Yeah, I think the way that I've kind of approached that specifically with criminal defendants, and this is probably a good point, because I'm sure that most of the listeners have wrestled with this at some point in a case. But early on, if I thought that my client's testimony was going to hurt them, obviously at the end of the day, it's the client's decision to testify. But I would all but say they were an idiot if they chose to testify. I mean, it was very much like, you absolutely should not testify. I would go through this like whole, explanation of why this is, really a bad choice. And the more now that I've kind of done this, I've kind of laid out here's some issues that we have if you testify. I personally am advising you not to testify. I think it really could hurt our case. There's doors that could be open that may be problematic. Again, this is assuming that testimony is not the right choice, because there are cases where I do think that a defendant's testimony can be helpful to the issues. But assuming that the general census would be that this would be a terrible decision, I've tried to put that little bit more into the client's court, explaining here are the problems that we have, because my feeling is that if the client gets to testify, and again, the stakes are not generally as high on most of these cases, misdemeanors, but if the client gets to testify and basically tell their side of the story, even if they lose, there is a lot of times, I think, a value in that to the client. There's something about being able to say my piece, whereas if you say to the client, if they decide not to testify and they think, this is because my attorney is basically kind of like, twisting my arm, if they're ultimately convicted, it's gonna be constantly the thought, the reason that we lost is because I didn't take the stand. And so there's some sort of I do think that there are clients that want to take a case to trial to tell their story. Maybe they really were treated unfairly by the officer. Maybe they really, don't believe that they were impaired. There was, medical impairment that is being alleged by the state. They don't believe that they were impaired. Being able to kind of tell that story is, I think, a big part of like the closure process for clients. So that, that's kind of been more of my approach. And I don't know how that conversation went between, Murdoch and his attorneys, but there was probably a sense that this was going to be an uphill battle. I mean, I would imagine. I don't know. I don't know. Again, obviously, a lot about that case, but I think from a defense perspective, we get really antsy as defense lawyers when we have to put anybody on the stand. Even if it's a non-defendant witness, we're not used to being the ones presenting evidence. And now, does this appear to be some sort of like burden shifting that's going on, or does this appear to be, us being seen as having to prove something? We're not very good. We like objecting and asking, leading questions that are rough. That's the general nature. But when your defendant gets on the stand, even if you've talked to them, ad nauseum about what they're gonna say, and you feel like this is going to be helpful to the case, your stomach is not in a good spot whenever you're a defense lawyer with your client on the stand. So I think it's just one of those things that that's been my approach to it. And again, I don't know.
Well, that's interesting. Getting your perspective as a criminal defense attorney in DUI in particular, because I can well imagine, after listening to you, that decision to put the client on the stand must have been extremely difficult, and kind of give an insight into particularly the younger criminal defense attorneys into the mindset of a prosecutor. Cross-examination is our pride and joy. We love to cross-examine, right? Because we're convinced, at least at the U.S. Attorney's Office, that 99% of the time that witness was lying.
Yeah.
Now, well, how do you approach it as a prosecutor? And so, young criminal defense attorneys, this is how we approached it. I hope nobody at the U.S. Attorney's Office listens to this and says, Broyles giving away the game. It's not that insightful. But what you do is, that the defendant, the witness, whether it's defendant or just a witness with a defendant, has a pre-arranged dialogue that they're going to present on the stand, right?
Yes.
Their lie, I'll call it, as a prosecutor, because I generally think they were lying. And so you knew what they were going to say. It goes back to what we were talking about earlier. As a prosecutor, you knew what their claim was going to be. What you have to do as a prosecutor, so listen to this defense attorney, is you keep them on the stand. It is hard to maintain a lie over an extended period of testimony. It's hard to keep those balls in the air and continue to juggle and keep them all fitting nicely. And so you can break down a witness's set of lies, and you can do it over a series of a number of questions. So you don't just go to, well, I know what you're going to say, and it's lies, and you can't do that, but you go into the nuances and the little things that would have to be true to support your claim. And they can't do that most of the time. I remember I had a one example, and we won't talk shop too much, but this was a cocaine dealer. He was a Appalachian State football player, and he was the main cocaine supplier many, many years ago at App State. And he took the stand, and I kept him up there for a good hour and a half. And near the end of it, he was starting to break down. He's a smart guy.
Yeah.
And finally, so I said, you weren't really dealing. You're arguing that you weren't really dealing these kilos of the cocaine. You were just helping people out at your parties get a little cocaine here and there, and they give you a few bucks, right? Yeah, that's it, right? Done.
Yeah.
Just admitted. Now we just have to go to amount. Right?
Yeah. Right. Right.
But that took a long time to get to the point where he got actually frustrated and tired, and we couldn't keep all the pieces of the lie together. So it's hard. It's hard to put it. I can feel I can understand your trepidation when it comes to putting somebody on the stand, because by golly, the prosecutor is finally going to find the weakness in their testimony.
That's such a great point. I think so often, as probably regardless of what side you're on of the table that you're on, you feel like that maybe you have one or a couple of kind of smoking gun questions that you're going to ask the witness that is on the stand. And so there may be the mindset that I want to jump right in and kind of just go after these big, these big issue
Haymaker
topics. Yeah, let's go in with that right hook and get this thing going. But there really is a attrition factor to that. I mean, where you just wear out the witness. And I've seen that with a lot of officers. I've seen that with my own witnesses, where you just have somebody on the stand and they don't want to be there. Nobody wants to be sitting in that witness seat. It's the worst place on earth probably to be, outside of like the electric chair. I mean, it just is a terrible, terrible feeling to be, up in front of, in an ornate courtroom in front of a judge and a jury, and you've sworn, you're just waiting for, you see these, defense lawyers licking their lips, waiting to ask you, questions and make you look like a liar in front of,
right.
everybody, the entire public. And so nobody wants to be there. So I think that sometimes not only are people worn out, but they're just looking to give you the answer so that you will stop asking them questions. Like they just want you to basically say no more questions, judge. So you kind of get this sense of like, what do you want me to say? Like, how can I say this thing the right way to where I can get off? And, I think that there are really trained officers and witnesses that kind of know that. And they just think, I'm in here for the long haul. I could be here all day and half the day tomorrow. And that's just the way that it is. But other officers are like, 10 questions in, how can I get off this stand? How can I get out of here? So I do think that playing that long game with questions is a huge advantage when you are getting that sense.
So many factors, and I agree with your analysis. So many factors go into that human being on that stand. What's going on in their mind? What kind of lies are they telling? What kind of pressures are they under? And to your point about sometimes it's okay, it's so unpleasant up here, I'm going to just get off the stand and say whatever I have to say to get off the stand. The example I told you earlier of the cocaine ring in the Waitsboro area and the witness I put up that I should not have put up because I deferred to my agent. Jim, the defense attorney, at one point after he'd beaten him down pretty badly, said, "You're just up here saying whatever the prosecutor wants you to say in order that he'll recommend you get a break in your sentence." And the defense witness was so tired and so frustrated, and he was not a good person anyway. He goes, "Yeah, man, I guess you're right."
Yeah.
Well,
yeah.
That came out in closing argument.
yeah.
Shocking. And we are.
Yeah. That's, that human element really does play into that. And in terms of, I think, prepping your witness as well, preparing them for that, hey, you might be up there for a long time. You're going to get asked a lot of, the prosecution or the defense attorney is going to try to, twist your words. If they do, just say, I don't think it, if you don't remember saying it that way, I'm not sure that's exactly how I said. I mean, you don't have to agree with everything just because you're getting asked a leading question by the other side. So,
When
I
did
think
you
that,
stop beating your wife, right?
yeah, that's right.
Yes or no?
Oh, I love it. Well,
Yeah.
well, maybe as we kind of come to a close, Professor Broyles, in terms of advice for young lawyers in particular, but criminal defense lawyers in general, what advice would you have to young lawyers that are listening?
Well, I think we've covered a lot, but if kind of to return to an emphasis, don't approach your job as an abstract, and so we can formulate this well, an abstract legal system that's separate from the realities of human nature and the realities of life in general. So our point's about humility. That's a human virtue. And it actually plays, not only is it human virtue, it plays out well in the courtroom. Right? These things translate in the courtroom. It's not a positive, law is not a positivistic, separate set of rules. They're simply a human creation. They're grounded in human nature, and what I call the laws of nature, nature's God, to echo the founders. And so all these characteristics make up a good human being, make up a good lawyer as well. Right? And the jury and the judge, I think, are going to sense that. If they're trying to tell the truth, trying to get not trying to twist, you said twist words or just make an argument, right? Then that inures to your capacity to be an effective lawyer. So being a good human being helps make you a good lawyer. I'll put it that way.
Love it. Well, thank you so much for coming on. It's been a blast catching up with you, and thank you so much for sharing your wisdom with the audience. Okay, Jake, I miss you. I miss you too. Okay, brother. I have to come visit. You're welcome anytime. Okay, thank you so much. You bet. Bye-bye. Bye-bye.